Thank you. Okay. You can have a seat, Mr. Posey. Thank you. All right, we're ready for the jury. Ms. Watkins asking them to join us. Thank you.
Special guest, if you got.
I did. All right. Thank y'all. We all, everybody cool enough, I guess? How about cutting that air, if you can help us with that, Mr. Whitley? Thank you. All right, ladies and gentlemen, we'll start off this afternoon with the cross-examination of Mr. Posey. Thank you. Please proceed, Mr. Merchant.
Inspector Posey, is one of the first goals in the interview to gain rapport with the interviewee?
Yes, to gain trust.
And the purpose of that, I thought I heard you just say, is to gain the interviewee's trust
Yes.
and to get them talking?
Yes.
And that's why you use open-ended questions?
Correct.
You're not supposed to ask questions that suggest the answer?
That's correct.
Because the interviewee can be susceptible to leading or suggestive questions.
That is correct.
The purpose of a leading question is to control the conversation.
I don't know. That's definitely something that can happen, but I don't know if that's the only reason that does happen.
But it's a way to introduce information that has not been offered by the interviewee. Fair?
Well, you do that.
You introduce information in a leading question.
Yes. If you're asking a leading question, I mean, there are leading questions you can ask that doesn't introduce anything that's of importance, such as evidence. But if you do that and there's evidence in there, like we talked about with the phone earlier, then yes, that happens.
All right. And did you take a look to see whether or not Agent Shidell introduced information in the interview?
The biggest one that I did, the biggest one that stood out to me again was the where he, in his question, he told Ryan about the cleaners, and that's where he disposed of the purse and the keys.
He also introduced the idea of the credit card.
He
right?
did. He did.
That was information Ryan had not offered.
Correct.
He also introduced the fact about Ms. Grinstead's house, the location of the crime scene, correct?
I don't remember that. He was not the first one to mention Tara. Ryan was the first one to mention Tara. But in terms of who first mentioned a specific location, I don't know.
Would you defer to Agent Shidell if he had testified about that?
Judge, I'm going to object. Sorry.
I'm sorry, go ahead.
So the question was, would you defer to Agent Shidell if he testified about that? I'm objecting to asking him to comment on someone else's testimony. Especially because he hadn't heard it.
Yeah, I'm not asking him to comment on the credibility of Agent Shidell. I'm just trying to figure out if he thinks that Agent Shidell would be in a better position to answer the question.
That's exactly commenting on Agent Shidell's testimony and whether or not he believes it.
It's not based on...
Yes, I know. I will rule that against. I disagree.
And so, sir, is it important for the agent to clarify any inconsistencies from the interviewee's account against other witnesses or evidence with additional specific questions?
It is.
That's from your report, right?
Yes, sir.
To use your house analogy, you don't want to build a house on a shaky foundation. That fair?
Well, for that specific things, that would be part of building the house, is getting the details and making sure the details are right. So that would be beyond the foundation, but just kind of flip the analogy around, and yes, sir, we agree.
Okay. So the whole point of following up on the inconsistencies is to make sure that you can resolve them as part of your interview.
Make sure your details are correct.
And if the details are inconsistent with the person's account, you need to do some more digging. Is that fair?
That's fair.
So in your words, I think you said you're looking for, quote, confirmation of details. Is that true?
Yes.
Do you know how many times Mr. Duke said, "I don't know," during his interview with Agent Shidell?
I do not. I did not count that.
If I told you it was 55 times, would that surprise you?
I know it was a lot.
And the fact that he said, "I don't know," does that lack of knowledge create gaps in terms of the agent's ability to corroborate the information?
It could.
And in a case where it was 55 times, there's a good chance you probably need to ask some more questions or do some more digging.
And I can recall some situations where, specifically where Agent Shidell was talking to him about how he got to Tara's house, and he responds, "I don't know." And then that's when he asked more questions, and his story changed to he stole the keys from the pockets.
But it creates gaps that have to be filled in eventually.
If you don't ask specific questions just like that to clean it up, yes. But you also got to understand, again, it doesn't, within an interview, as I talked about earlier, training in controlled environments, it looks one way. When you take it to the real street, yes, you want to learn as much as you possibly can, but it doesn't mean you're ever going to learn everything. Like in the end, we would like to know everything. It just doesn't always work out that way for us.
And I understand you may not learn everything, but you should at least try to learn as much as you can. Is that
I agree
fair?
with that. I agree with that. I do.
As part of your work on this case, did you come to learn how many locks Miss Grinsted's front door had?
I did.
How many does it have?
One.
So can you see the photo I published? This is previously admitted as State's Exhibit 76.
I do.
All right, sir, can you see whether or not there's a hotel-style lock above the lower door handle lock?
Above it?
Yes.
I don't know what that is.
You don't know what that is?
I don't. From that picture, I don't know what that is.
You can't tell that that's a lock?
I don't know what that is from that picture.
Okay. Well, let's assume that that's a lock that can only be locked from the inside. We've had some testimony about that. Can you assume that with me?
Okay.
So would that be an important inconsistent fact if Miss Grinsted, if there was testimony that Miss Grinstead always locked that door or routinely locked that upper lock when
Which
she
I'm
was...
going to object to a hypothetical that is not based on evidence in this case. That is completely an inaccurate statement of what the evidence has been related to the top lock.
It's been a little conflicting, but I'm going to rule that objection. Go ahead.
Sir, if they're assuming that she locked that upper lock when she was home at night, okay, would that fact, if that were true, would that be inconsistent with Mr. Duke being able to gain entry into that house using a credit card only on the lower lock?
Yes.
And the credit card, do you have personal knowledge as part of your investigation about whether Ryan even had a credit card at that time?
I do not.
And as a GBI official, are there ways for GBI agents to obtain records that would confirm that one way or the other?
If he personally owned a credit card at that time,
Yes.
I would think through a credit history report that you can learn if they have a card at that point.
And if he didn't have a credit card at that time, would that also be in conflict with the story he gave that he used a credit card to get in the house?
I wouldn't go as far as to say that, because I don't ever recall him saying I use my credit card.
But it would be worth investigating. Is that yes, sir?
Yes, sir.
Okay. And I only say that because she can't take
I understand.
down the head
Yes, sir.
nod, that's all.
That's my fault. I apologize.
So I want to turn to your testimony about there being no evidence of a crime, or being evidence of a crime inside. So the pictures on the wall, Ryan didn't reference that those were Miss Grinsted's, did he?
When he's being yes, sir.
He said
When he's being specific to how did you identify her, and his response is pictures on the wall, that is a direct reference to her picture.
Yeah, I want to be more specific. I'm sorry, I asked a poor question. He didn't say those were pictures of Tara on the wall.
I guess I'm confused on how it would relate to him answering the question if it's not hers. I guess that's the part I'm confused.
He just didn't offer any
Y'all both
information.
got to speak up a little bit, okay?
He just didn't offer any information that the pictures themselves depicted Miss Grinstead.
Again, I believe with him answering the question in the manner that he did, he's telling you it's Tara's pictures.
But that's not a particularly specific piece of guilty knowledge, is it?
That was in independent collaboration, not guilty knowledge.
Okay. But in any event, most people have pictures hanging on their walls inside their house, right?
I would say that that's common.
That you had testified about the blood on the comforter.
I'm sorry, I just can't see what we're looking at.
Yeah, I'm going to identify it. This is
Okay.
this is State's Exhibit 120, sir. Can you take a look at that?
Yes, sir.
Is that the blood on the comforter that everyone's been talking about, you've been talking about today?
Is that the comforter on her bed?
Yes, sir. Is that the blood that you talked about earlier on the comforter?
That is the blood that I believe was referred to in the summary and that is consistent with the picture that I saw.
Okay. Well, let me ask you this, sir. With all your years of training in the GBI, is what we're looking at consistent with a fatal blow to the head that causes bleeding?
And I am. I'm going to object at this point as it relates specifically to, just because the way the question is asked, I think it calls for a medical conclusion. I think there is a way to ask the question that he would probably know the answer, but what he has asked is that consistent with a fatal blow to the head, which I believe calls for a medical conclusion.
I'll try to rephrase, Judge. Let me see if I can break it down. And can you let me know if I can't? If I'm not being heard over there, I promise I don't project particularly well. Not much of a screamer. So, sir, I want to sort of focus in on these couple of areas on the comforter. Does that look to you to be consistent with what we would refer to as menstrual blood? As a crime scene person.
I have no way of knowing that.
So in terms of your review of the interview in this case, where Ryan says he struck her on the head once and that she died, if you're using the blood that we're looking at here as evidence of that, is that what you're doing?
No, sir.
Are you suggesting to the jury that this is evidence of a crime, or are you not doing that?
No, I was not. I was only pointing out that in my statement, to be completely transparent about the part about the scene where Ryan said there's no blood at the scene, and the crime scene specialists find no blood at the scene, to be 100% to not appear to be misleading, but understand there was some blood found on the comforter.
But you're not.
But I'm not saying anything specific about that blood.
Okay, you're not suggesting to the jury that it's evidence of a crime.
No. No, sir. I apologize.
And I think I understood your testimony earlier, but there's no physical evidence that anyone was killed inside the house, to your knowledge, from your work.
Not from my assessment of just the crime scene.
In the course of your work, sir, did you come to learn whether the front door was unlocked or locked on Monday morning?
I don't know the answer to that.
Well, if the door was locked on Monday morning, would that suggest to you a fact that someone had locked it from the outside on the way out?
On the outside?
If the door handle, the doorknob was locked when people first tried to make entry on Monday morning, would that suggest to you that whoever went out last turned around and locked the door?
No, sir. It would actually, that's a possibility. But since I've done this before, to break into my own house, if I use the card, all it does is move the latch. It doesn't turn the latch on the back of the doorknob. So it'll still be locked. It just moves the latch away from the impression in the door frame.
But the door, whoever went through it, the door was locked when they left. Is that fair? As an investigative fact, that'd be something you either know or you have to follow up on.
I don't know. I don't know if it was locked or not.
Well, Ryan said in his interview that he went back to the house around 9:30 in the morning, or the morning of Sunday. Do you remember that?
I remember there being some discussion about time, but I did not recall them really hammering down a good hard time.
But he went back to the house. In his interview, he said he went back to the house to get her body, correct?
He did.
And Agent Shidell suggested that's when the glove was dropped, right?
Correct.
So if he goes in to get her body, carries it out in a quilt, puts it in the truck, do you believe him doing that, he'd be able to see a glove sitting on the ground?
Well, to use his to take his own words is just a big mistake. So I have no idea if he can see it or not.
Well, if he had to lock the door, if he carried her out and put her in the truck, and he had to go back and lock the door, that'd be two opportunities for him to see the glove, right? If he dropped it on the way out.
See, again, I'm held up on him having to go back to lock the door, because again, if we're going to because we're doing a lot of assuming here. If we're going to assume that his statement is correct, and he uses a credit card, the door's still locked. So you don't have to go back to do anything. You just have to pull the door shut.
And I'm not suggesting that we assume anything. I'm asking you questions based on things we know in the case evidence and whether or not those create inconsistencies with his story.
Well,
so let me
I guess I got confused when you made the statement that he went to the truck and then came back to lock the door. How do we know that if we're not doing some assuming?
Is that a fact you could have asked, or someone could have asked Ryan about in the interview?
It could have been asked of him in the interview.
Are you aware of testimony from Larry Peterson, a GBI trace evidence person, who told this jury that it's highly unlikely that the fibers found on the glove would be from a blanket or a quilt?
I don't know anything about testimony from Mr. Peterson.
But if that were true, would that create another inconsistency in Ryan's statement?
That if the fibers found on what are inconsistent with the quilt?
Glove.
What quilt?
It would create another question that would have to be followed up on. Fair?
They're inconsistent with what quilt?
Larry Peterson told us that there were fibers on the glove, and that on questioning from the state, said it's highly unlikely that those fibers are consistent with coming from a blanket or a quilt. If that's the case and it's true, doesn't that create another inconsistency in Ryan's story that would need to be followed up on?
If that were true, but if we don't have the quilt and the blanket, I don't know how you say that it's not the same. I don't understand that.
But my point is, you'd have to go find out.
If you can find it.
So Miss Grinstead's car, I want to talk to you about that. Did you develop information about Miss Grinstead's car at all as part of your work?
No, sir.
And I know this was not an issue that Agent Shidell focused on in the interview, but did you find anything as part of your work important about the car?
I didn't review anything about the car because there were no statements made about the car.
If you learned that Miss Grinstead always locked her car door, but that on Monday morning when it was first opened, it was unlocked, would that create a question that would need to be followed up on?
Yes, sir. And the best person that can answer that is Miss Grinstead. And from there, it's going to get difficult.
Right, but doesn't it also create an opportunity to ask Ryan another question about the car?
Absolutely. Anything can be asked of Ryan if in that moment you are aware of it or think about it. I agree.
And so Ryan told Agent Shidell he didn't really remember the car. Do you remember that?
No, sir, I don't remember that.
And if there was money found in the car that was unlocked, and Ryan's story was that he had gone to her house to burglarize her, would it be inconsistent that it would be a burglary if there was money available in the car?
Not based on what I know. And again, my knowledge is very, very limited from just doing the assessment in the crime scene. So I'm very limited, and you're asking me some very broad questions about many other areas that I did not look into. But the only way I can answer your question is not that I know of.
There's also been testimony that her car was not at her house until late Sunday, even though Ryan indicated in his statement that this happened Saturday night. You agree that he said this happened Saturday night in his statement?
I remember him being, yes, I remember him being a little confused. Jason, or Agent Shidell, is the one that introduces Saturday, Sunday, not Ryan, but I do remember Ryan did not correct him. So Ryan's recollection was that actually it was September, late fall, was his recollection of it, but he definitely did not correct Agent Shidell.
So if Miss Grinstead is home inside her house and the attack allegedly happens in there, and her car is found late Sunday, and there's testimony that it wasn't there during the day on Sunday, would that create another question that you would need to follow up on in terms of trying to evaluate Ryan's statement?
That's a judgment call from the agent doing the interview at the time, especially if, as you just told me, because I don't know this, he already said, I don't remember anything about the car. That agent in that moment could easily make a decision that if you don't remember anything about the car, there's no reason to continue on with that line of questioning.
But that wouldn't be true if you had knowledge that it was unusual for her car to be unlocked, especially if she's not there, right?
Again, that's a decision that agent has to make at the time based on what you've told me that he's already. I don't know what question is going to keep coming after that if he's already said I don't remember anything about the car.
He couldn't ask him, hey, her car was unlocked. Do you know anything about her locks?
I don't remember anything about the car.
But isn't part of what Agent Shidell did here continue to ask questions when he said I didn't know?
He did, but I guess what I'm missing here when it comes to the car within my assessment, within the assessment of what's being done at the time is I don't know how the car was important in the middle of that interview. I understand what you're saying now based on other things, but again, in the middle of that interview with the questions that Agent Shidell is trying to focus on and establishing the facts, what in that interview pointed him to say, let's focus on the car? He asks a question and gets a I don't know, but I guess I'm a little lost to second guess him sitting here when I wasn't there to say, well, he should have said this and he should have said that. Well, okay, sure, that'd be great, but I also can't fault the fact that he asked about the car, gets an I don't know question, and says, okay, there are more important things to me to talk about. Let's go to other important things.
But you just used the phrase that Agent Shidell was focused on that. I thought you testified on direct that the story should come from Ryan. Is that true?
You just confused me.
Well, I'm not trying to confuse you. You said Agent Shidell was focused. It wasn't relevant to what he was focused on at the time.
Meaning trying to learn. Trying to learn. There still has to be in an interview somewhat of a funnel effect of starting really, really wide. And you still got to make a decision on where that starting wide is. And there's a point where things have to narrow. Just like you asked me earlier about open-ended questions and then continue on. There has to be yellow lines on the road. There has to be. Sure, there's later times you can come back and second guess and say, well, then your funnel should have been this wide. Well, we can always do that. I promise you there's never been a time that I've sat right here and reviewed my own interviews and didn't think, I should have asked this and I should have said that and I could have done better here. That'll happen every single time.
So my questions are less focused on that and more on resolving inconsistencies in the statement versus the case evidence. I'm just trying to figure out,
yes, sir.
Based on what your testimony was, what should be done in terms of following up. If you have information that the car was unlocked and that's unusual, that would be a fact you'd want to follow up on. Is that correct?
Yes, sir.
Is it fair to say Ryan was kind of all over the place when he was talking about the glove? In terms of his knowledge of the glove, where it came from, that sort of stuff? Was he sort of all over the place with that initially?
I would define the entire interview as being all over the place.
So one person has testified that they did not see a glove in her front yard at 6 o'clock on Sunday. If that's true, would that also be inconsistent with Ryan's story about going back Sunday morning to get her body?
Yes, sir.
And if another witness, captain in the police department, said he went to her house Sunday midnight and didn't see a glove, and that he thought he would if one had been there, is that also inconsistent with Ryan's story that the glove was there 9:30 or so, whatever time in the morning on Sunday?
If we make the assumption that this witness did not miss the glove laying there.
But that would be true if we assume they could see it.
We're having to assume that they should have seen it, and we're having to do a lot of assuming here.
Yeah, you.
Sir, have you read the 2014 article written by Michael St. Ives entitled Interviewing Suspects?
I have.
What was your response? I'm sorry?
Yes, sir, I have.
Okay, sorry.
Okay. And I think you actually cited that in footnote 2 of your report, correct?
I did.
So the authors say that, quote, leading or suggestive questions are not only counterproductive, but also highly unlikely to contaminate a suspect's account. Would you agree with that?
Can be. Definitely can be.
So leading questions can lead to interviewer contamination of the account.
Definitely can be.
And I guess in the GBI manual, you talk about the reasons why people might lie. Is that correct?
In the GBI manual?
Yes. Does the GBI manual provide reasons why people might lie?
Be a little bit more specific. I don't understand your question.
With all of your experience at GBI, do you know or have you been told or do you teach others that they may lie for their personal safety?
It's definitely a possibility, definitely a reason.
And for the safety of their loved ones?
I've heard it before.
That's all I have, Judge. Thank you. Thank you.
Can you read it up?
Just a few very brief questions, Judge. In your training or your years of experience, have you ever known people to steal credit cards when they burglarize homes?
Yes.
Okay. In your years of experience, have you ever known trained officers to miss important pieces of evidence?
100%. It's, as I said earlier, with my review, audio transcript is done because I know I'm going to miss stuff if I don't put them together. So, 100%.
In your years of experience, have you ever had just what we call lay witnesses, non-law enforcement officers, not see particular pieces of evidence?
Yes, yes.
In your years of experience, and now I want to talk about interviews, but specifically as to witnesses, have you ever had witnesses get confused about the dates that something occurred?
Yes.
Does the length of time between when the act occurs to when they are interviewed about the occasion that occurred, does the length of time between those two increase the possibility they could be confused about dates?
Yes, it can increase a number of things about their memory.
Okay. Defense counsel asked you questions about if Agent Shidell had heard or had known that fibers found on the glove were inconsistent with that being of a quilt, should he have followed up with more questions about the quilt? Is that essentially the question you were asked? Do you recall?
I don't think that was the question.
Okay. Do you recall being asked whether or not Agent Shidell should have asked more questions about the quilt?
Or maybe I misunderstood the questions. I thought the questions about the quilt were would this make Ryan's statement being inconsistent with Ryan's statement?
Okay. So I guess let me ask this differently. Do you recall or do you remember if Agent Shidell specifically asked Ryan if he still had the quilt?
He did.
Okay. Do you recall what Ryan's response was to that?
He did not have it.
And defense counsel asked you about the word contamination. And I know that we didn't use this specific, or did we use that specific word earlier when we were talking or when you were giving your direct examination?
I don't remember.
Okay, let me ask you this then. Do you recall if we gave the jurors examples from this interview of contamination?
We gave a specific example of contamination being when Agent Shidell told Ryan about the cleaners, and that's where the purse and the keys were disposed of.
Okay. And again, because I don't think I used that word earlier, trying to keep it simple, other than that area of contamination that you've already talked about with the jury, did you see, or based on your review of this interview, any other areas of contamination in your review of this?
Not when it was specific to the evidence.
Okay. And explain, if you can, for the jury why that part is important, that it was specific to the evidence.
Well, Agent Shidell may have asked leading questions, but if it wasn't specific to the evidence, which again, in my assessment, that's what I'm looking for. I'm looking for Since I have that foundation of the admission of guilt, I'm looking for the details. Well, the important thing is the details need to come from Ryan. They don't need to be introduced or taught to Ryan by Agent Shidell. So that's what's important, is understanding that the details come specifically from Agent Shidell. Now, there are other things like the credit card that Agent Shidell does introduce. But there are also other things that were equally important and in connection with that Ryan introduced. So in terms of just saying that because Agent Shidell said this, we kind of need to slide that evidence over here and not consider it. The only time that I saw that was specific to the cleaners, the dumpster, the purse, and the keys. All one event.
No further questions.
Any follow up, Mr. Murphy?
Yes, Judge. Sir, do you remember that Agent Shidell had to ask Ryan 8 separate times about the glove before he admitted anything about the glove?
I don't remember that. I didn't count those.
But would that be consistent with your memory, even if you can't remember specifically, around 8 times?
Honestly, I did not remember them discussing it that much.
So your testimony today is that you don't remember how many times he asked about the glove?
Correct. I do not remember how many times they asked about the glove.
But it was multiple times, if you remember, right?
Honestly, I don't remember.
So the glove is an important piece of evidence in the case,
It is.
and your testimony today relates to Ryan's knowledge of that critical piece of evidence in his interview, right?
Right.
But you can't tell the jury how many times roughly he talked about it before Ryan said yes, sir.
Give me a second, please.
And sir, I don't need you to look for every single one. I'm just trying to make
Judge,
sure.
I'm actually going to object. He's asked the question. He's made a point to say you can't answer it. He has a chance to review his notes to see if he can answer it.
He's welcome to, Judge. I didn't want to waste everybody's time.
Go ahead. Let's take a second. Thank you.
Yes, sir. I definitely didn't record 8 times. No, sir.
Okay. Well, how many did you record?
Just from that brief look, there was two that jumped out at me.
The brief look over, what did you look at?
Transcript. So I started with so you'll see the highlight, you'll see the citation number behind where we talked about the gloves, which 26. That refers us to a specific area in the transcript, which is lines 14 through 16. What was my time again? Sorry. So I see I have it underlined as being the first time it's mentioned at 13:17. And then line 25. Again, then they have the conversation about the gloves. And then the next page, they have a conversation about the color of the gloves. So that's, to me, that's all, that part, even though it's on 3 different pages, is all one conversation.
So you're treating that all as one,
Well, it's just continuation.
Okay.
I mean, again, there, like we talked about earlier, the whole interview at times is a little fragmented, so there's, but yes, there's some coming back too.
okay. So let me just close the loop on this for everybody. Is it fair to say that in that portion of the interview, the gloves are discussed several times?
Yes, sir.
And have you ever testified on behalf of a private entity or citizen?
No, sir.
All of your testimony has been on behalf of the GBI?
Yes, sir.
And you had 2 expert cases where you testified in trial?
2 other cases, yes, sir.
Okay. And was one of those with Miss Hart?
No, sir.
None of those have been with this district attorney?
No, sir.
Thank you. That's all I have.
Thank you, Ms. Hart.
I do. So at the 13:17 mark, 13 minutes, 17 seconds into the first interview, did I understand you to say that's the first time you have seen that the word glove is brought up in the interview?
Yes, that's what I have in my notes.
Okay. And can you tell the jury what question is asked about Agent Shidell at that point?
Let me refer to it, please.
Sorry. I believe it's page 16 on the transcript.
The question from Agent Shidell?
Yes.
Tell me about the gloves. I know there's gloves in the house. Is it going to have your DNA on it?
And what is Ryan Duke's response to the very first time he's asked about the glove?
It should. Because they were at my house.
Sorry, I interrupted you. Go ahead. What was the rest of it?
It should because they were at my house.
No further questions.
All right, Mr. Posey, thank you for your testimony, sir.
Thank you.
I'm going to excuse you at this time to go on about your business, all right?
Thank you.
Please
y'all.
call your next witness.
Judge, I would, again, retender States Exhibit 293 being the certified copy of Bo Duke's conviction out of Wilcox County in case number 2017 CRW 38.
Certified, you say?
It is.
Thank you.
Judge, we would just object on relevance grounds.
Okay.
We weren't allowed to cross-examine him, so we can't question him about this.
It's a certified record from a court of record. I'm going to admit it. I think that's it. So, takes care of the authenticity. All right.
Your Honor, with that, we have no other witnesses and the state filing closes.
All right. Y'all need a minute, or y'all want to put up any servable?
No.
Okay.
We don't have any rebuttal. Thank you, Judge.
All right, ladies and gentlemen, the evidence is closed. You've heard all the evidence you're going to hear in this case. I've got to go over the charge, which is the law that I'm going to go over with you tomorrow after the closing arguments. In a case such as this, both sides are entitled to 2 hours, up to 2 hours, to argue their case to you. I'm not saying they will, but they have that right under the law. After that, I will give you the charge. That is the law. And then you'll be asked to commence your deliberations. But until that time, don't deliberate, okay? Don't discuss the case with anybody. Don't allow anybody to discuss it with you, just like we've gone over before. As a matter of scheduling, I want to speak with them outside your presence for just a minute. And that is such a small room. Every time I walk in there, I can't imagine all 18 of y'all in there. Step out to the grand jury room for me. Maybe you'll be a little bit more comfortable, and I'll be right with you. Thank you. Please be seated. Where's Mr. Norton? Need Mr. Norton. Mr. Norton? Raise your right hand for me. You swear you're going to testify to the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Off the record, prior to starting back after lunch, you brought something to my attention about an inquiry from 2 jurors over the lunch hour. You recall that?
Yes, sir.
We spoke with the attorneys about it before we started back after lunch, but not on the record, so I want you to repeat for our record what it was 2 jurors spoke with you about over the lunch hour. And I don't want you to identify those jurors, though, but I want you to tell us what they said to you and how it came about that you were approached.
They first approached one of the other bailiffs and said they had a question that they needed to ask someone. The other bailiff got me, and they asked me, they said, 2 of our fellow jurors are spending most of the time or doing a lot of sleeping up here. What, if anything, is going to be done about it? And I told them, I said, I can't give you any answer, but I will contact the judge and tell him of your concerns, which I did.
Thank you for handling it that way. Anybody got any questions for Mr. Norton about that communication? From the state?
Judge, the only issue that I would have, and I know the court was careful not to ask that, is we may need to have those jurors that asked him put that on the record, that they had noticed that the complaint came from other jurors, and they may need to put that particular thing on the record.
Okay.
I think both defense counsel and state's counsel have noticed it through the trial and have noted it repeatedly through the trial.
I would say, from our perspective, that's the only time I've seen that was today. I know one of the jurors, he puts his head down and he plays with his hair.
Right.
I've seen that.
Do you have any questions for Mr. Norton?
I do not.
Okay.
I do not.
Thank you, Mr. Norton. You can step down. Go ahead, Mr. Gibbs. No, I want to hear from you. I just want to let him get off the chair.
Yeah, that's right, Your Honor.
Yeah.
One of the jurors that we're referring to, I know that even when we were doing voir dire early in the process, he has a tendency to, he looks down and he plays with his hair, twists his hair a little bit. And I've noticed that, we noticed it during voir dire. I believe someone thought he was asleep during the process, but I was seated right here very close to him. And it became apparent when somebody touched him that he just didn't realize that he was being spoken to during a question. He just had his head down. So I've noticed that a couple of times. I have not noticed him, and I've not noticed the other juror ever nodding off or sleeping.
I've noticed it particularly today and I don't know the numbers off the top of my head. I think maybe it's juror number, let's see, I can figure it out. Jurors number 71 and 78, and they're seated next to each other. I noticed, and I brought y'all, before the lunch break, I mentioned it to y'all. I did notice after you approached the bench and brought to my attention that after lunch, the same 2 appeared to be nodding off. Even after that, juror number 71, got his attention. And then it wasn't about 5 minutes later, the juror to his left was bumping him again already. So I'm going to bring Mr. Thomas in, that's his name, juror number 71, and question him. I'd be glad for y'all to question him if you'd like. Bring in juror number 71. Mr. Thomas, have a seat for me. Thank you. Raise your right hand for me. You swear you're gonna tell me the truth, whole truth, and nothing but the truth, so help you God?
Yeah, I do.
Thank you. You're having a hard time today.
Yeah, there.
Do you work at night, by any chance?
Well, sometime.
Did you work last night?
Yeah, there.
I noticed this morning you appeared to be asleep. You think you nodded off this morning?
Yeah, there.
And again after lunch. Did you nod off again?
Yeah, there.
Anybody got any questions for Mr. Thomas?
Just a quick question.
Please.
It appears there was a limited amount of time that you were sleeping. Did you observe most of the testimony today while you were here with us?
Yeah, there.
You know what the last witness's testimony, what was his testimony about?
I had to look at my notes.
Okay.
Can we approach for just a moment before we continue? Sorry. Or the way they need to be, given that we have a juror on the stand.
Yeah, surely they're not.
I'm showing the judge and I'm showing you.
Great.
Thank you.
And then audio from the juror
The audio from the juror
is what
the audio from the juror
can be heard. Okay. Sorry, I just want to make sure we were that. So go ahead.
Oh, I was just gonna ask, so you took some notes today?
Yeah, there.
Okay.
Any further, Ms. Hart?
No, I don't have any further questions. Thank you.
On some previous days in the trial, looks like you had nodded off a time or two.
Yeah, there.
All right. Mr. Thomas, I want to excuse you from the jury at this time. But you're not in any big trouble. Over your objection, I get it. You're in a spot with working at night, having to come down here and stay awake all day. It's critically important to both sides. And I appreciate your service, what you've been able to do for us, but you're going to be excused from the jury at this time. You can go on about your business, sir.
Your Honor.
Yeah.
May I make an objection on the record?
Of course, yeah, sure.
Thank you. Under the code that's applicable here, section 1512-172, a juror can only be excluded, excuse me, if the juror dies, becomes ill, or is unable to perform the duty. I've got a number of cases here, the Georgia Supreme Court and Georgia.
I've watched this juror sleep on and off for a week and a half. He's excused. Over your objection. I get it. Thank you. It's timely made, overruled, and preserved for the record. Thank you. He admitted he has to work at night, and slept through the trial on numerous days. All right. Anybody else? Any other jurors we need to question? Ms. Hart?
And I apologize if I haven't stepped out, but there is the other juror that's named who was pointed out by her fellow jurors.
Okay.
I know, I just would ask that we either question her or question the fellow jurors about the situation.
All right. Ask juror number 78 to step in. 78. Good afternoon, ma'am. You're not in any trouble. Just have a seat. Let me ask you a couple of questions. Raise your right hand for me. You promise or swear to tell me the truth, whole truth, and nothing but the truth. So help you God?
Yes.
Thank you, ma'am. You had a hard time staying awake today, son?
Because I work every day.
I get it. I understand. Listen, I'm not mad at you or anything.
I tried.
Ma'am?
I tried.
Yes, you do. I'm not saying that you haven't. But have you just not been able to stay awake? today?
Just today.
Just today? Did you miss much of the testimony, you think?
No.
Okay.
I still took notes and I still heard everything.
Okay. So you weren't asleep then, is what you're saying?
Mm-mm.
Oh, okay. Well, just from where I was observing, and even the attorneys approached before the break, and it appeared a
I
couple
could
of jurors was asleep.
I still
Were
heard
asleep.
everything.
You still heard everything. Good deal. Anybody got to ask or like to ask this juror any questions? No, Your Honor. Okay. You confident you heard the testimony?
Yes, sir.
Thank you so much, ma'am. You can return to the jury room. All right, Mr. Rigby, do you believe it be appropriate to question the jurors who brought this up to the bailiff today?
Your Honor, I'm actually at this point satisfied with where things are. It may just be that we need to put on the record what jurors at some point, maybe not on television, but what jurors actually brought it to their attention, so that that's on the record of those things.
Okay. Y'all want to ask the jurors that reported their concerns about the two jurors sleeping on the record?
No, Your Honor.
Okay. As I understand from what we discussed in chambers, the jurors that brought it to your attention were 18 and 64. Let's have the charge conference in about 5-10 minutes. Take a recess. We'll turn the air back on, please. Thank you. right, let's go over the charge, please. Where's Lindsay? It's all right. I'll find it. Request to charge first, please. All right. States 1.20 presumption of innocence, burden of proof, reasonable doubt. Everybody got the draft that I've provided them, I hope. What's in front of you should be from the pattern. Is there any objection as it's prepared in the charge now?
No objection.
All right, thank you. And comparing that then, Ms. Merchant, if you're up on your side, I got so much paper down here now. Here it is, defendant's request. That would that'd take care of your charge number 1 as well, right?
Yes, Judge.
Thank you. All right, state's request about evidence 1.3 as it's in the charge now. I think it's pretty close to the pattern. If y'all will take a look at it, it's the one I think I've made a modification or two just to try to make it sound a little plainer. Have y'all seen the plain language charge committee now that they're doing to try to make these charges a lot clearer, shorter, more concise? It's a lot better. Any objection to the evidence charge, Ms. Hart, in the draft?
No, Your Honor.
All right. Any objection, Ms. Merchant?
Which is that number 6, Judge?
Number 6.
No
Just
objection.
take a look at it. All right. 6 is okay then, or the evidence is okay. And that is your charge number 4. 4 and 5, okay. 1.3, direct and circumstantial evidence, that's contained in the number 6 in the draft, so we'll mark that one off. Credibility of witnesses should be right out of the pattern, although I have charged it in the past with the consent of the parties to just tell the jury judging credibility of people is what you do all day, every day. Do that. But if y'all want me to take it right out of the pattern, I'm glad to do that. What's the state's preference?
The state's preference is to take it out of the pattern, Judge.
Is this the pattern that's on here?
Yes.
We're fine with what's on here.
All right. That's 1.31 for the states, and yours is requested charge number.
Should be 6, Judge.
Credibility of witnesses. Thanks. Conflicts in testimony, Ms. Hart, I think has been repealed or taken out. I didn't see a similar request in the defendant's.
Judge, this came directly from the new pattern charges.
Okay, good. Let me pull it up.
But yes, that's what I was trying to do as well. So we
Take a look at that.
had just recently, thankfully, gotten the new pattern charges. And I almost exclusively request patterns, so.
Well, that is the safest usually. Way to go.
suggested pattern jury instructions with the date of January 2022.
Well, that sounds like the most recent.
And we're talking about
13120.
Okay, so 1.31.0 did get repealed. This is 1.31.10 credibility of witnesses.
All right, I'm looking at your request. It says 1.31.20. This says there is no charge on this. Conflicts in testimony. So what you're talking about is credibility of witnesses. We got that in there. That's the jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances.
So you're, sorry, I apologize, I missed it. You're talking about .20, not .11?
The next one on your request to charge is 1.31.20.
I would withdraw that, Judge. I apologize.
I don't
was
have,
confused.
is the 11 is polygraph, right?
Yes, but there is a .20, but that is the former charge.
Right.
Thank you.
It's taken out.
Correct. So I'm incorrect about that one.
No, no
don't
problem.
know how I got it in there.
I'm sorry, I wasn't communicating with you. Expert witnesses, I have pulled right from the pattern. If y'all will please just scan that. I don't have it in this. Can you print another one, please? Good, thank you. Any objection to the charge on expert testimony as it's presented now?
No, Your Honor.
No, Judge. And that's the state's 1.3130
And your
7.
number 7. Thank you. All right, now we're back to impeachment and credibility, prior statements. Please take a look as it's drafted now. It may need some more added to it.
Do you know where, is in yours, Judge?
It's number 7.
Oh,
Right, maybe?
is it under credibility of witnesses, Judge?
Yes,
Okay, thank you.
should all be there together. Thank you, Lynn.
It's good for us, Judge.
All right. Is that acceptable then for your number 8, 9, 10 then?
Yes, Judge, for us.
All right, thank you. Ms. Hart, that'd be okay for your 131, 40, 45, I guess, and 47.
Sorry, man, just a moment, Judge. I'm just comparing it to the newest pattern.
No problem. It may have a little tweak in it.
So it actually appears to be, it does appear different, Judge. Would you like me to read what 1.31.40 is, just so we can all decide?
Yes, hang on just a second.
Certainly.
All right, 131.40. Go ahead.
May I remain seated? I'm reading on.
Yes, everybody, please do that.
In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to, and these are options, to attack, to cast doubt upon, to challenge the credibility or believability of, or to cause you to disbelieve any such witness. Those are all options the court can give.
Right.
this would include evidence of, and then it gives you the options, character for untruthfulness, which we obviously have had here, an attempt to show character for untruthfulness. It also then talks about specific instances of conduct of the witness in question, brought out on cross-examination, and that of another witness that may relate to the witness's character for untruthfulness. It also then talks about bias.
Yeah, I've got bias in there.
I did see that the bias and lack of bias is in there. We have had felony conviction, which is another form in which the witness may be attacked. And then also...
Who did that come up on?
Bo Dukes.
Bo Dukes, because he was allowed to be called as a witness even though he took the fifth. They were allowed to tender to the...
Yeah, but no live witness was really.
Well, I mean, even though he didn't testify, that was a
I'll
live
charge
witness.
on it. I mean,
Okay.
I'll charge.
And then crime of dishonesty, which again I think would be given that the theft that they were allowed to tender.
Was that admitted? I
It
didn't
was.
know
His embezzlement, yes.
Okay, thank you.
Or conspiracy, whatever.
I know you were talking about it, but I didn't remember you tendering it, but if you did, you did.
So that's the end of 13140, Judge. Do you want me to go on to 13142?
All right, out of what you've just gone over, we'll add then the provisions about the character and reputation evidence for untruthfulness. There is no other bad acts, right? Right?
No, Judge.
No, Your Honor.
Bias is already in there. I'll keep that. Felony conviction I'll put in. Is there any reason to add the crime of dishonesty conviction as well? I mean, they're both felony convictions.
I think that's a question for the defense, Judge. Those
What's
are the ones
your
tendered.
preference? You want me to?
We might as well add it. It's not long.
I don't mind.
Okay, thank you.
I think it'd be appropriate. Thank you.
The other portion, Judges, is of that is,
Give me just a second.
sorry.
It's all right. All right, thank you. Go ahead.
It also specifically references in the main portion that it's not just that a witness's credibility may be attacked, but it also goes through that language, cast doubt upon, challenge, credibility or believability, or cause you to disbelieve any such witness.
You want to include all of that? I'm glad to.
I'm just always cautious and believe that the pattern is the better choice. But again, I guess that would be a question for defense counsel.
I don't mind doing that. Does that suit you? Just to...
I agree with Ms. Hart. I always think the pattern is the best
What
choice.
did you say?
I know. Everyone, please take note. I think the pattern is always the safest bet.
That'll be fine. Thank you all.
Would Your Honor, does Your Honor have the pattern that I'm looking at? If not, I can email it to you if you'd like.
I have it right here. Thank you. And I will add that verbatim. All right, anything else? Y'all satisfied with the prior statements as it is in there?
Missing? Under section 7?
Yes.
Yes, we are.
So again, I'm just looking at what the pattern says, and because this was specifically done by included by defense counsel, an attempt to do that. Under 1.31.42, witness supported, which I'm assuming is what you're talking about, prior statements.
I'm talking about prior inconsistent statements.
Okay, you're talking about inconsistent right now.
Yeah.
Then we're fine with that, Judge.
All right, witness supported. I have a good character charge in there, but let's see what this one says. Determining credibility has been attacked. Where applicable evidence offered to support the credibility or believability of such witness, and this would include character truthfulness and any lack of bias. I certainly don't mind giving that. I think it would certainly apply to Mr. Duke.
Thank you, Judge. We would ask for that.
All right. What about lack of bias? I mean, I can put that in and the jury can decide that. Does that suit y'all?
Are you giving, before I answer my question, sorry, Judge, are you giving that entire paragraph character for truthfulness, including the part about specific instances of conduct of the witness in question brought out on cross-examination?
I don't know about any specific acts. I don't recall that from the
As it relates
testimony.
to character for truthfulness, Judge, we not only talked about, more specifically, I asked him about it, but I do believe there was evidence otherwise of the fact that he told lies outside of what he claims he lied
And then
about.
we got the bad character evidence in there too.
And I guess just because we're going to be talking about character for truthfulness, I would just request that we give that entire paragraph related to also specific instances of conduct, because there were specific questions that were asked and answers that were given showing that he lied to Zach Gerard for the first one that jumped out.
Yeah, I'm sorry, you're right. Outside of the reputation
Yes, Your Honor.
and opinion evidence.
And that was, obviously, some of those things can only be allowed in because the good character evidence was brought in. So.
All right, any objection to, that would be 131.40.
131.40, the old impeachment charge?
I thought we were on .42.
I'm sorry, yeah, 131.42, excuse me.
Right, no, we have none to .42.
Great. All right, I'll add that. All right, defendant statement, I had drafted that charge. On bottom of page 4, top of page 5. Let's see where my page 4 is. Yeah, number 9 in this draft. You'll please take a look at that. And that should be right from the pattern.
I think that's both, I think both the state and the defense requested that.
Right.
So Judge, under are we just doing, are we doing all of your statement of defendant number 9? Okay. Under 132.17, there's a second paragraph that's in parentheses. I just want to make sure that, I'm not necessarily requesting it, I just want to make sure that defense counsel has looked at it and is not requesting it.
Necessity imposed by others. Yeah, it's parentheses. I'll put it if you want it, Ms. Merchant.
I thought you had that in part of yours, but if you
Well,
didn't-
I have it at sort of the bottom
Okay.
of, it's all up to them.
Yes, and we would,
All right, I'll put that in. Thank you.
I think number 12 is really number 10.
You think number 12 is really number 10? What?
The corroboration of defendant's statement. Unless I'm losing my mind with the numbers.
Yeah, we're not there yet.
Oh, okay. I thought that's where we were.
No objection from the state as to what Your Honor has under statement of defendant number 9.
All right, and that, as far as the numbers go on the pattern, goes all the way through 132 point, skips over the juvenile,
I think 5-0, Judge?
skips over the, yes, all the way through 5-0. Down to corroboration, 132.7. Let me mark these off real quick. So, one's a circumstance. All right, as to the defendant's statement, then, Ms. Merchant, I'm checking off your charge request 14, 15, 16, 17, 18, 19, and 20. So we're down to, it's the same request. 132.70 is your 21. It should be right out of the pattern as it's in there. You'll please double check that for me. Which is 12, like you said. My numbers are going to be off here in a minute. Ms. Hart, you okay with the corroboration of
Yes,
the
Your Honor.
defendant's statement charge?
Yes, Your Honor. Looks like it's straight out of pattern.
Yes,
Moves
You
around
okay
it,
with
but-
it? Good,
yes.
all right. We'll
Thank
leave
you.
it in as it is now. All right, next, identification. I don't think you made that request, did you, Mr. Merchant?
I didn't.
All right, how's that,
If they're not
You think it's-
requesting the burden of proof for identification, Judge, then we're fine with that not being given, but that is in fact something we have to prove.
You can give it,
And this is not the one, I guess I should say, this is not the identification charge that relates to out-of-court identifications.
right.
It relates to the identification of proving that the defendant is the one who committed the crime.
all right, this is 135.11 we're talking about. Let me get, I don't have it in here now. Let's take a look at it.
1.35.11, yes. No, we would ask for that one, but not the other one.
Okay. Defense wants 135.11, right?
Yes, Judge.
All right, I'll give that. All right, next on the state's list is 135.20 and 135.20 and then 135.30. Fingerprints and DNA. They should be right out of the pattern as they exist in 11. I got two 11s. Fingerprints, the first 11, and DNA evidence is 11B, which I'll of course change, but y'all take a look at that. It should be right out of the pattern.
Oh, this is the pattern. That's why I'm doing that. Judge, may I,
Go ahead.
sorry, the only thing that we would ask is, at least in the beginning or at some point in the charge, when it references fingerprint, perhaps have something in their fingerprint and or palm print, just so it's clear, because the testimony was that it actually came from, they believe, from the palm. I don't want the jurors to take it too narrowly. I don't know that it has to be added every time, but just to clarify.
I don't have any problem with that.
Or you could just say print evidence, either way.
That'd be a good solution. All right, does it look okay otherwise on fingerprints?
Yes, Sharon, thank you.
Ms. Merchant?
Yes, it does. Thank you.
Thank you. All right, what about DNA? Y'all had a chance to look at that?
No objection from the state.
No objection.
All right, that's 11B on the list, 3530 on the states. Your request to charge number 25 will check off, Ms. Merchant. All right, next on the states list is 13615. I did not add that in.
We didn't think it applied.
It doesn't apply anymore, Judge. We had asked for that originally, not knowing if we were going to call Garland Lott in our statement in chief, or excuse me, in our case in chief, which we didn't. And so Garland Lott's testimony was actually admitted as a prior inconsistent statement.
13615 is withdrawn then. Good
Yes, Your Honor.
character is the state's next, 13710.
We would ask for that as well, Judge.
I think it's, did you have it?
And the traits, I had asked Mr. Gibbs, I think it was peacefulness and truthfulness.
Thank you. That's my recollection too. That should be right from the pattern.
Looks like it does.
Looks like it does too.
All right, Ms. Hart, peacefulness and truthfulness as the particular traits. Evidence was offered of. Any objection to those?
No, Your Honor. We obviously, I put that in there just because we want to make sure doesn't get left out and there's error induced. So whatever the defense counsel wants, I'm fine with
Yeah, I
that.
think that's perfect. I know you would have brought it up, but I don't see it in one of your specific requests, Ms. Merchant, but we'll certainly add that.
Thank you, Judge.
All right, definition of a crime, 140.10, that should be back on the first page somewhere. All right, let's see. Yeah, number 4. But I haven't checked to see if that had changed since the last version.
Yeah, it's number 4, Judge. On page 2.
Looks straight from the pattern, Judge.
Okay, we'll give it as it's in number 4 and check that off both lists. Thanks. Intent is next, right under it. Number 5 now on page 2, please. Double check that one. That also encompasses your 28.
That's what I just noticed. Thank you, Judge.
Does that check out all right with you? The intent charge, Miss?
Yes, Your Honor.
Okay. We'll check those off, thanks. All right, venue, state's requested just the general venue charge, and I left that in there, but I've also added, Ms. Merchant, your request as to special circumstances. There was a number of choices through the pattern. I picked out 2 of them, I think, if you'll take a look at those and see if those are satisfactory.
Yes, Judge. I read those, they are. Thank you.
All right, Ms. Hart, I think I left italicized what I wanted to specifically bring to your attention.
And that's from the pattern, please. May I have just a moment, Judge?
Yeah, that's on page 10 under number 13
All right,
from the
that's it.
draft.
Thank you. I mean, it's a proper statement of law. I suppose it goes along with their argument.
I think it'd be appropriate to give it. Any objection from the state?
No, Your Honor.
All right, thank you. All right, let's go back to, let's see, we got at the bottom of your first page, top of the second page of your request, Ms. Hart, looks pretty specific to the charges. So let me go through some of these other evidentiary. Accident is your request number 29. Ms. Merchant, is
Yes.
that, you still request that?
I'm flipping back through where.
I've got it there listed as one of the number 12s. It's at the top of page 8. It's not, I mean, your theory is we weren't there, right?
Right, exactly.
So it'd be appropriate to take that out.
We can take that one out, Judge, yes.
All right. All right, so your request to charge number 29 is
Withdrawn.
Withdrawn, thank you. I did not include the knowledge request. I don't mind. It was one that I had down at the bottom that I could just cut and paste and move on up. Is the defense still requesting number 30?
I believe it's number 12 on your page 14. And we are requesting that, yes, Judge.
Ms. Hart?
Sorry, I have just a moment, Judge. Just want to make sure I'm correct on what the pattern says on that. So if Your Honor is going to give that charge, we would, and I may have requested and I just don't recall it, but if Your Honor is going to give that charge on knowledge, we would ask that the court also then give charge on parties to the crime. Judge, he's not charged as a party to the crime. The statute doesn't require it, and the charge actually says that in the statute. Judge, there's been absolutely no evidence whatsoever to support a party to a crime charge.
Well, he could, it would be a party to the crime of concealing the death.
In Ben Hill County.
Judge Garland Lott testified just today that he heard whichever one of them say it, joke around that they together killed her and they together burned the body, and that Bo Dukes and Ryan Duke were together when the statement was made, and that they were both laughing amongst themselves. Taking that into account with the other evidence in this case, there is certainly evidence that the jury could find they acted as a party to the crime.
Judge, we don't mind withdrawing 12. It's just, I think it'll confuse the jury. So if party to a crime and knowledge go hand in hand, we're fine withdrawing knowledge.
Judge, we would actually ask the court to give both, I think. And I don't believe I included it in my written charge, but I am now orally requesting that 1.4210 and 1.4211 be given, and I think it would then be appropriate to give the knowledge charge.
Go ahead and take a look at those two, please, Ms. Merchant, 142.10 and 11. Any other thoughts on parties to the crime, failure to prosecute the principal, and knowledge?
I don't think it applies, the party to a crime, and we're fine without that, taking out the knowledge. I just think it would confuse the jury, and there's no evidence to support that. A hearsay statement that someone said after the fact is not enough to support party to a crime theory.
It's a very reasonable thing for the jury to wonder about, even though there's only the one defendant in this case. I intend to charge 4210, 11 in knowledge. If y'all see something tonight, if you're looking over anything and any cases you want me to review about that, I will be glad to reconsider. But I'm going to give that over the defendant's objection. All right, that's 30. Mere presence and mere association. I typically give those all the time. Ms. Hart?
No objection.
Any objection to those? I don't know that I had plugged them in. I think I just had them sitting there on the bottom of the last page. They should be precisely out of the pattern, and I'll double check that. And please, if you see anything wrong, let me know. But I give defendant's request 31 and 32. Statute of limitations or defendant's request 33.
We also have this request, Judge.
And 34. You have that too?
I just did it as a specific request. It's our specific request 1 and 2. Okay. And 3, actually.
Please take a look. 1, 2, and 3. Please take a look at the way it is presented in the draft. Yeah, on page 8. Thank you. I think that covers all of it. Does that suit the state as it's drafted now in 12 on page 8
So Judge, my only concern with it, and I actually like the language you used better than what I took from the pattern, but as to the third paragraph, in that statute of limitations under number 12, where it says any period of time during which the evidence shows the person committing the crime was unknown, that is not how it was alleged in the indictment. It was alleged specifically, the second part of that, which is the crime itself was unknown.
Shows that the crime itself was unknown?
Yes, sir.
You
So
think
I
it
would just ask that it conform to the indictment.
Take out the part about that the person committing the crime was unknown.
Yes, sir.
Is that what you're saying?
That's fine with us.
All right, that third paragraph, for any period of time during which the evidence shows that the crime itself was unknown.
Otherwise, we don't have any objections, Judge.
All right, anything further on the statute of limitations part, Ms. Merchant?
No, Judge.
All right, the verdict form is 14 in the draft on page. And I'll just tell you, I typically don't read every one of those. I'll have it in the draft like this to send out with the jury, but I'll just go over the verdict form as to the first count, typically is what I do, and then tell them to apply that analysis to every count in the indictment.
I know how Your Honor does it. I'm satisfied.
And you have, and your boxes, you have the boxes next to it where?
I'm talking about in the charge right now.
Oh, in the charge. Okay, I thought you were actually talking about the form. I was trying to follow
Yeah,
it.
well,
Okay.
do you have a copy of the form? I have it. Hang on, let me print that out now too.
Oh, that'd be great.
Thought I'd already given it to you.
I don't believe, unless it was with that email,
That's-
I missed it. I don't think we have it
That's
at all.
my fault. That's my fault. Must have it under second. All right, Miss Forshee, are you? There you are. I need you to bring your chair right. All right, we need 2 of these, Miss Forshee. They need them. If you just, oh, you're fine. Any objection?
Yes, not guilty, she will
I get that. Do you care?
Judge, we're.
We have no objection to it.
I'll invert it.
Thank you.
All right, so noted. I'll make that change. Next, let's see. Still on yours, Ms. Merchant. No need for the lesser. What about 38? You want to
No, we don't need that.
withdraw that? All right, 39. Court's lack of interest in the case.
I think you have that early on.
Yeah, it's in the on the last page 13. Nothing I did during the progress of the trial was intended to express any opinion about the facts of the case, credibility of any witness upon the evidence, or the guilt or innocence. My interest is that the case be fairly tried according to law, and that you, as honest, conscientious, and impartial jurors, consider the case as the court has instructed you, and return a verdict speaks the truth as you find the truth of the case to be. Is that acceptable?
Yes, Your Honor. Yes, Judge.
39, then deliberations is part of that section on page 13. Your request 40 unanimous verdict is in there too. That's request 41. 42 is in there as well. If you'll double check those, please, Ms. Merchant. Make sure those are like you want it.
I don't think the retire to the jury room is in here, but I don't have strong feelings on that one way or another.
It probably, you may
It
narrow
might be somewhere else, I just may be missing it.
I'll put it in.
Okay, thank you.
Number 42. All right, on both lists now, I'm down to the specific charges. Is that consistent with where you are?
Yes, Your Honor. Yes, Judge. Well, there was one that was skipped, but I can go back.
Oh, yeah, please, let's go back. Sorry.
Number 2, grave suspicion. I don't believe that was in there. I may have missed it.
Well, it needs to be in there. I think I've given that every single time.
I thought it was in there too, but it's not. I couldn't find it.
Thank y'all.
Thank you.
Your Honor, I'm assuming you're gonna take out one of your number 12s, the defendant's choice not to testify?
I am.
Okay.
All right. Back on the state side, the malice murder charge looks like you're proposing is a 2005 version.
Yes, Your Honor.
It is different now. What's your reaction to that?
Judge, I think you should give the current charge. And so it's my understanding that the things that are different are the second paragraph at the top of page 9 is to be murder. The killing must have been done with malice. That is not in the state's charge. And then also The current one says malice may be implied, and the state says malice shall be implied. I think malice may be implied is the appropriate charge.
Where did you get this charge?
I copied it. It's not a charge. It's directly from
The
the
old
statutes
statute?
of 05, which is what he's charged with. And to charge the jury on anything different than the 2005 malice murder would be error. And it would be charging him with something that was not a crime, or charging him with a different crime than what he's charged with. But I copied and pasted that from the 2005 version of malice murder.
All right, Ms. Merchant, don't you think it's appropriate to do the 2005 version?
Judge, I think it's appropriate to do, because we're following a pattern charge, and the pattern charges are updated when new case law comes out. And so just like we're following the rules of evidence and the case law as of today, for confrontation, for example, we're not following where the law was in 2005. We're following where it is now. Pattern charges are not the statute. We don't just cite the statute. We cite different things than the statute. It's based on case law also. So I think the appropriate charge is the current pattern. It doesn't change the crime.
Have you compared the 05 version of the murder statute to the current murder statute?
Not recently, but I can do that right now, Judge. I did do that back in 2017 when we indicted the case. And I can go while I'm looking this up, I can go and tell you that my concern is, yes, as it relates to evidence law, it applies for when you're trying the case, but whether or not the crime was more stringent for the state to prove or less, charging him and telling the jury he's charged with a crime that didn't exist in 05 is an ex post facto law, where we'd be prosecuting him for the wrong crime. But I'm pulling up that statute, Judge.
Let me grab Title 6.
Would you like me? Sorry, Judge, I have it.
You have the 05 version, right?
Yes, I do. Just copied and pasted into my request.
All right, you're saying this is the cut and paste from the 2005 version, because it is precisely the current version.
The 2005 statute, yes, Your Honor. And yes, they are precisely the same. I'm looking at them now. The statutes themselves are precisely the same. But to answer your question, what I put in there is copy and paste.
If it's the same statute in 05 as it is now, why shouldn't we do what Ms. Merchant suggests as far as the pattern charge? I mean, there is no ex post facto problem if it's the
same statute.
precise
I agree
word.
with you, Judge. So I'm thinking, I'm trying to make sure there's no error, so give me just a moment.
I mean, I think if there is, I mean, she's asking for it. I don't think it. Well, maybe on an ineffective, but they're not ineffective.
Well, I don't disagree, they're not ineffective, but obviously we always have to be considering everything, Judge, as the state, so.
All right, let me pull it up too. I'll look at it.
Yeah, so it's actually suggested.
Now, this is one of McBurney's new charges, I think. This plain language stuff they're doing now.
I know, I think he actually was recommending taking out the last 2 paragraphs, but.
You may find.
You know that, so on the top of page 9, the state does not have to prove premeditation to prove murder.
That's in it.
That's in it now. I think that was one of the things he was talking about. I mean.
You see the current pattern charge there before you, Ms. Hart?
Yes, Your Honor, I'm looking at it right now. So,
I just don't see any problem at all. If it's the same statute in 05 as it is now, I'm going to go with the current
that's fine,
pattern
Judge.
charge, okay?
I mean, no objection, I guess, obviously it's fine, but we don't object to that. Like I said, I was just trying to make sure there's not a problem there that I'm not thinking of.
And I'm pretty sure that's the way I've got it in here, but I'll double check that against the pattern and do it precisely as it is. All right, next is the felony murder charge, which is always a problem. You got the 05 statute? Can you pull that up for felony murder?
That's also copy and paste of it, yes, sir, I can.
All right, is it the same? The subsection C.
It's the same, Judge, in 05.
All right, but now they've added this causation part to that.
That jury charge was added by case law.
The causation charge is added, yes, sir.
Right, right. All right, any objection to that? I think you both asked for that, didn't you? The causation?
I think so.
No objection, Judge.
All right, we'll do the causation after the definition. You may find. I think I've got it in there already. All right. Let's take a look at, please, the aggravated assault, burglary, and concealing the death of another.
Sorry, Judge, before we move on from the murder, we had also specifically requested the premeditation charge and the motive charge related to malice. We can come back if we need to. It's in the same portion of the pattern.
It's in there.
It's in there, okay.
The last 2 paragraphs, please take a look at those. Let's talk about it
perfect.
now.
Okay, I see it now, Judge. Sorry, I just missed it. Thank you.
All right, y'all take a look at the aggravated assault, burglary, and concealing the death of another.
Burglary obviously has definitely changed.
Right.
Aggravated assault, Judge, I believe this portion of the aggravated assault statute has not changed. They did add strangulation, but I do not believe that 6561. But I'm going to pull it up just to make sure.
Mr. Mr. Merchant's getting me the indictment. I wanted to see how it was phrased for aggravated assault, sorry.
Problem.
But I agree, they added strangulation, that's the big change, but it's got to track however it's indicted.
Take a look at it.
Thank you.
And I can tell you again, it's
I
copied and
intended
pasted.
to track the indictment, anyway.
Apologize. It's copied and pasted. What is in my aggravated assault request to charge number 6 is copied and pasted from the 05 version, related to what's narrowed to what we indicted.
All right, state doesn't want a lesser included on the malice, I don't guess. You got the felony murder.
No, Your Honor.
All right, simple assault. All right, is that language still the same in the new or most recent version of the aggravated assault statute? The part you charge, subsection 2, I guess, right?
Yes, Your Honor. Yes, Your Honor.
Okay.
And the indictment,
I've got the indictment.
you got the indictment correct? Okay.
With his hand, an object when used, which when used offensively against a person did result in serious bodily injury by using his hand to kill, tear, fray against. That should be the way I put it in there.
So, Judge, in the way that you have it,
No, it says
sorry.
deadly weapon is subsection 2. All right, go ahead. 3.
So, the way you have it in that first paragraph, this is a proper statement of the law. However, given how it's charged, it just causes me some concern. Where it says to prove assault, the person does not have to prove that the other person was actually injured. That is a correct statement of the law. However, because of the way that we charge the aggravated assault, they are actually required to find that it caused serious bodily injury. I just don't want them to get confused between those two.
I agree, Judge. That was the sentence that prompted me to ask Mr. Merchant to go get me the indictment.
Good, thank y'all. All right, so we'll take out, all right, for aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon and must prove the defendant attempted to cause a violent injury to the person.
So, actually, Judge, I think because we're taking out the second sentence, the third sentence should come out as well. Those are actually alternative ways of committing assault.
But isn't that the way you charged it? The violent? Hang on.
No, Your Honor.
No, they only charged it the first sentence.
All right, what about the second paragraph then?
No objection from the state to the second paragraph.
All right, Ms. Merchant, we're talking about then for aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon And then just going straight into the second paragraph at the top of page 10. Any objection?
No, I think it's appropriate.
All right, thank you. All right, the burglary account is next.
I think it's appropriate.
And that has significantly changed, as you say, Ms. Hart. Any objection to 5, burglary
No, no
definition? Ms. Hart?
No, Your Honor.
That's right out of, and count 6. Any objection as it's drafted here?
No, Judge.
All right, didn't you have a couple of specific requests? Let's see, Ms. Merchant, if we hadn't gotten to, I guess not, okay. Do y'all think there's any charge that needs to be made out of Mr. Duke's appearance and his taking of the oath?
Can't think of any.
I mean,
Just the traditional witness ones that we've got.
yeah.
I would ask, sorry, may I, Judge? I would ask the court to give some of the language from the Sweat case related to that, essentially that there should be no presumption of anything one way or the other, and I'll have to pull up the Sweat case.
Listen, I understand y'all's reliance and insistence on that, my consideration of that Sweat case. I didn't go along with you on it because, you know, that's a 95, I think it's an old case. We've changed the law. That was pre-impeachment of your own witness, and that was just back before when we didn't tell juries a lot of things we should have told them. I mean, it should be up to them. I get the part about what the appellate court was concerned about, but I still think, and that's why I had him come in. It's their case. It's y'all's case, and they need that information as far as I'm concerned. As far as what the appellate courts at that time were thinking could lead to such confusion on the jury's part, if you want to draft something up and have it in the morning, I'll look at it. I'm not saying I'm going to give anything, but that's what I was thinking. I just think that if you'll give them some help about it, I don't mind doing that. And the only thing I consider was telling them about them, don't worry about it. Everybody has the right to take the fit. And you shouldn't draw any inferences outside of that.
Yes, Your Honor.
Outside of the exercise of someone's constitutional right.
And I wasn't planning to re-argue Sweat issue. I just wanted to say that I would ask for some sort of charge related to that. And I'll send that tonight.
Please be sure to send one to Mr. Merchant.
Is it possible if there is going to be one presented, we could get it tonight by like 9 o'clock? I go to bed. Thank you.
I do too. Except when I get stuff from him.
Oh yeah, he doesn't go to bed.
No, he's up. All right. What else can y'all think of?
Judge, we actually had another request to charge related to intoxication, voluntary being no excuse.
Involuntary intoxication?
Involuntary intoxication.
Or voluntary?
No, voluntary intoxication.
Not being excused. Did I not have that in there?
We didn't talk about it, and I don't believe I saw it in there, but we would request that.
Judge, we have to admit the crime in order to get that? Like if we admit the crime and say that he did it but he was intoxicated, then they're entitled to that. But that's not what we have here.
He did admit it in his confession. And during his confession, I understand they're saying that's a false confession, but during the confession, which was played to the jury and they have the right to consider, he specifically indicated he was high and drunk when he committed the crime. And so I think it would be appropriate for the jury to understand that if they decide to believe what he said back in 2017, that is not an excuse. I understand they're not going to argue that, but that's the law.
Is that what you were expecting to hear, Ms. Merchant?
No, it wasn't in the written charges, so I wasn't expecting it at all.
It was in my request.
It's in your request. All right, I'll charge that over objection. I think that'd be appropriate because of the statement that came in. All right. As far as the arguments go, do you know, Ms. Hart, if you and Mr. Rigby would split it up, or I don't have any problem if all three, you know, if everybody wants to take a topic or a portion of the argument.
We do not intend to split it, Judge, and in fact, there's a statute on point that says that that's not allowed. I had this come up recently, and I think it may say if they intended to do, if we intend to do that, we have to give notice. Don't quote me on that last part, but there's a very specific statute on point that goes against that, and we do not intend to split it.
Do you object, I guess? If they
We would, yes.
Judge, I think the statute she's referring to is 17870 in criminal cases, except by express leave of court, no more than 2 counsel may argue in closing for each side, and only 1 counsel may make the concluding or rebuttal argument. So 2 lawyers can argue the closing.
Do you agree within my discretion?
I have to take again, it's been several months since I had this come up, so I have to take a look at that specific statute, but I didn't know they were going to attempt to do that, and we were going to discuss it, but, and I'm looking at sweat, but certainly I can try to look at that.
Go ahead and take a look at that, and I'm going to allow it, if it's within my discretion to do so, for the defense.
Is that as to all 3?
No, up to 2. Do you intend to make some opening remarks as far as your closing goes, and then sit down and then come back?
Mr. Rigby's actually going to do the closing argument.
Okay, sorry.
I don't know the answer to that, but normally he does not. Normally he just reserves.
Okay. So y'all will be up first, if the regular pattern holds. Anything else?
Not from the defense, Judge.
There you go.
Listen, thank y'all. Y'all have done a great job for both sides of this case, and I'll see you in the morning, 9 o'clock.
Is it possible to get an email of your charges?
Oh, yeah.
The final one? Okay.
And I'll send it out to you before I leave.
One other issue, Judge, this came up during the questioning of Mr. Duke by the state on the issue of statute of limitations in Ben Hill County. He was asked about that, and he specifically said, I've got no knowledge about that.
Right.
So there's no evidence of that in the case, so we want to make sure that the state is not referring a closing argument to a statute of limitations issue in Ben Hill County.
It's the law. We can certainly argue the law. Whether he knows it or not is not what would be argued. It's the fact that he can't be charged in Ben Hill County. That's a proper statement of the law. Nothing that prevents us from arguing the law, even if, Your Honor, we don't request Your Honor to give it, as long as it's proper. Certainly can argue that.
Y'all objected to that question, is my recollection, and I allowed him to answer if he knew, and he said he didn't know. Never been discussed, right?
What he claimed, yes, sir.
And Judge, there's just been no factual evidence, testimony or otherwise, that relates to the statute of limitations issue in Ben Hill County, other than what they have put up in terms of the searches. So I don't know, the jury's going to be very confused at best about what to do with that information once they get it from the state, because there's not going to be anything in the jury charge about it, and there's not going to be any evidence about it.
All right, Mr. Rigby had to leave, obviously.
He did, but Judge, again, there's never any evidence as to the law. That's what the court is supposed to do, and as long as it is a proper statement of the law, we are allowed to argue it. The court is actually going to charge them that as to concealing a death in Ben Hill County, that there's a 4-year statute of limitations. If there's confusion caused by that, then we're stuck with that confusion.
Well, the confusion is the Ben Hill County part. I'll charge them there's a 4-year statute of limitations on this charge. Right?
Oh, I agree, Judge. But what they're trying to say then is that we can't argue that there's also a 4-year statute of limitations in Ben Hill County. And again, I don't know that he intends to do it, but that is a proper statement of the law. Whether or not he knows that or not, it is not what would be argued.
He's not been charged in Ben Hill County with anything, correct? Mr. Duke.
He is not, no sir.
Right.
But the jury doesn't know that. That's not information in front of the jury.
I probably, we'll talk to Mr. Rigby in the morning, see what his thoughts are, but I'll probably not allow that. Okay. All right. Hopefully about an hour y'all have this, and if you see any errors I'm liable to make, please just let me know.
Thank you, Judge.
If something comes up overnight, we'll talk about it in the morning, okay?
Have a great night, Judge.
Thank you.
Y'all have a good night.